our final written address dated the 8th day of July, 2022. But filed on the 13th day of July, 2022. Yes. We humbly adopt the said final written address in urging your lordship to dismiss the claimant's case and enter judgment against the claimant as per our counterclaim.
Yes.
I believe they will adopt their response before our reply. The reply that we filed, subject to your lordship's directive.
Yes. Yes, Mr. Oladipo.
Much obliged, my lord. My lord, the claimant's final written address is dated 15th August 2022 and filed on the same day, dated 15th August 2022 and filed on the same day. We raised 3 issues for determination, my lord, and we humbly adopt the entirety of the final written address and urge the court to grant the claimant's claims and dismiss the counterclaim with substantial costs, my lord. My lord, yes. We also filed a list of additional authorities. Dated and filed on 29th September 2022. And we also want the court to be guided by the additional authorities.
Yes.
We also forwarded a copy of the unreported judgment of the High Court of Lagos State to your lordship and to Learned Counsel for the defendants.
Yes.
As copies. My lord, may I just make 1 or 2 points before I rest? My lord, the claimant's claim is based on sex discrimination and pregnancy discrimination, on sex discrimination. And pregnancy discrimination is a subset of sex discrimination. And this could arise in not employing at all, or in the course of employment, or in the determination of unemployment. My lord, in this case, our claim for sex discrimination arose in the determination of the employment of the claimant. Yes. Also, my lord, sex discrimination can either be subtle or direct. My lord, in this case, it is both subtle and direct.
Yes.
And the best evidence, my lord, is found in Exhibit C40, written by the defendant's counsel.
Exhibit what?
C40, my lord. C40.
C40.
C40. by the defendant's counsel. Well, where the court finds that there was sex discrimination, whatever step or the steps taken in consequence of discrimination would be null and void. And that is why we are referring to the case of the additional authority of Shokefun and Akinyemi, my lord. Shokefun, Akinyemi, my lord. And then, my lord.
Is that the High Court's decision?
No.
Not an additional authority.
That's the additional authority, my lord. The additional authority. Number 2 on the additional authority, on the list of additional authorities.
Yes.
And just to drive home the point of the condemnable discrimination in this case, my lord, I would like to also just point out to the court. And I'm going to, I've cited an authority, an English case, a book called Discrimination Law by Michael Connolly. My lord, and I want to refer to page 120, paragraph 4.047, my lord.
It's in your address. It's in your address.
I will forward a copy to the court. It's not quoted. I'll forward a copy to the court, and then to Larry Castle for the defendants.
My lord, I think it's too late in the day to be forwarding authorities to me after the adoption of the addresses. Of what benefit will it be?
Sustained. You have already adopted your address.
Office. My lord, okay. My lord, okay. So the other authority is Attorney General, number 1 on the list of authorities, Attorney General versus Botswana versus DOW, D-O-W. Attorney General Botswana.
It's on your list of authorities.
Yes, my lord, on the list of authorities, number 1 on the list of authorities, my lord, particularly at page 132, page 132 of the law report, which we have already forwarded to the court.
Yes.
And then, sorry, and then I'm sorry, also, my lord, also page 129 verses paragraph E to F, 129 E to F, my lord. 129 E to F. My lord, the last point I just want to raise, my lord, is that on the point that international conventions and treaties are not applicable in this case, my lord, I submit, my lord, that municipal laws, the laws of Nigeria, must be presumed not to be in conflict with the international obligations of Nigeria. And therefore, where there is a breach of international obligations, the breach will be read in the context of whether it's in compliance with the international obligations and not with municipal laws. And that's what the court decided in Attorney General of Botswana versus DOW. So I urge the court to hold that the law of contract in this case must not be in breach of the international obligation to respect the rights of the claimant to freedom from discrimination, from sex discrimination, my lord. That's my submission. My lord, on the defendant's final written address, it was filed out of time by the defendant, and my lord, I urge the court to strike that as being incompetent.
Yes.
I am grateful to the court. I urge the court to be persuaded by the arguments in the claimant's final written address.
Thank you, my lord.
Yes.
Yes, on behalf of the defendant counterclaimant, we also filed our reply address dated the 25th day of August 2022. Filed on the 25th day of August 2022.
Yes.
We humbly adopt the said reply address in urging your lordship to discountenance the submissions of my learned brother Silk for the claimant.
Yes.
My lord, just 2 points from what my learned brother Silk just submitted.
Yes.
My lord, the first is that their case is not on discrimination at all. We are bound by the reliefs submitted to the court for determination. No case of discrimination was made out, I humbly submit. In fact, my lord, the evidence before your lordship was that even by the claimant herself, was that she was never discriminated against. So those cases that Malane Brother Silk has cited are totally irrelevant, inapposite, and inapplicable to this case.
Yes.
Then secondly, my lord, on the issue that we filed our defendant final written address out of time, I submit, my lord, that that is totally misconceived. We filed it within time. And we are guided by your lordship's rules. In this regard, my lord, may I humbly refer your lordship to Order 57. Order 57, Rule 6, Sub-Rule 4. Order 57, Rule 6, Sub-Rule 4 of your lordship's rules. It says, my lord, that in calculating the period of default, Saturdays, Sundays, and public holidays shall not be included, and time shall begin to run from the working day following the day the order was made. But if all these are taken into consideration, in fact, the day we started filing a Friday before, the next working day, which was supposed to be Monday, was a public holiday. So we had to file on the 13th. So we were within time, my lord. So I submit, my lord, that the submission of my learned friend totally misconceived.
Yes.
In fact, if I were to object to their own written address is the one out of time, because after we filed and served him, he didn't respond. Their own written address is the one that is out of time. So I urge your lordship to strike out their written address. Since they want to take a pound of flesh, I urge your lordship to strike out their own written address because it was filed well out of time. So finally, my lord, I urge your lordship to be guided by the pleadings and the reliefs sought by the parties. We are most grateful for the kind indulgence of this honorable court, and we urge your lordship to dismiss their case, the case of the claimant, and grant the counterclaim. Very much obliged.
My lord, may I be heard on the issue that we filed a claimant's final written address out of time,
Yes.
and to say that we did file it within time. If you had filed it out of time, we would have gladly brought an application for another for leave to extend time. And we urge the court to discountenance the arguments of Linet SCN for the defendants. Much obliged, my lord.
December 2 for judgment.
As the court pleases.
December 2 for judgment, and
As the court pleases, my lord.
the judgment will be, it will be delivered virtually.
As the court pleases.
And if there are any changes, we will inform council accordingly.
Grateful, my lord. Court pleases.
Yes. The case is adjourned to December 2, 2022 for judgment, which will be delivered virtually.
As the court pleases.
We are much obliged to the court.
Thank you. The court will
As the court pleases.